Ready, start. In our view, it would be possible and easy to contemplate such a situation arising, which leads us to the postulation that in a more technical sense, terms single inverted comma legitimacy, single inverted comma clause, and single inverted comma paternity, single inverted comma clause may indeed undertake different meanings. Full stop. The question that, however, arises is whether the law contemplates and accepts such a differentiation. Full stop. To answer this, we deem it appropriate to investigate the law governing the presumption of legitimacy and paternity globally, followed by its analysis in India. Full stop. Since time immemorial, English courts upheld that where a husband and wife cohabited and no evidence of impotency was forthcoming, the child is conclusively presumed to be legitimate even though the wife is known to have been guilty of infidelity. Full stop. To date, the presumption that a child born in wedlock is legitimate, has held the floor. Full stop. Earlier, the courts held that evidence from the spouses to disprove legitimacy was inadmissible. Full stop. Over time, this strict rule was relaxed and the parties were permitted to rebut this presumption by claiming non-access and leading evidence accordingly. Full stop. Advances in science and social transformation led to the passing of the Family Law Reform Act, 1969. Full stop. It was later replaced by the Family Law Reform Act, 1987. Full stop. Initially, the presumption of legitimacy could only be rebutted by proof beyond reasonable doubt. Full stop. However, by virtue of Section 26 of the 1969 Act, the presumption could be rebutted on a simple balance of probabilities. Full stop. This legislation also empowered the courts to conduct paternity tests to determine the biological father of the child, even without the guardian's consent. Full stop. Any person could apply to the High Court for a declaration as to whether that person is the parent of another person. Full stop. The court may refuse to hear the application if it considers that the determination of the application would not be in the best interests of the child. Full stop. Despite this, the family court has continued to uphold the rule that single inverted access single inverted clause must be proved with cogent evidence and that it is insufficient to merely show that opportunities for sexual intercourse existed. Full stop. Thus, in England, the presumption of legitimacy exists to date. Full stop. As illustrated, it can be rebutted by claiming non-access and leading evidence to prove so by a simple balance of probabilities. Full stop. In United States, state laws presume that a child born in wedlock is the natural, legitimate child of the mother's husband. Full stop. However, the rules concerning the presumption of legitimacy and the evidence necessary to rebut it vary from state to state. Full stop. As a result, the US Supreme Court has had few opportunities to discuss the marital presumption. Full stop. For example, the US Supreme Court dealt with a case where the respondent claimed to be the biological father of the children, though they were conceived during the subsistence of a valid marriage between the appellants. Full stop. Despite the Californian evidence code permitting the results of DNA tests to be admitted into evidence to determine paternity, the US Supreme Court noted that the law retained a strong bias against ruling the children of married women illegitimate. Full stop.